Chair lays that on second reading Senate Bill 15. The clerk will read the bill.
SB 15 by Betancourt relating to size and density requirements for residential lots in certain municipalities, authorizing a fee.
Chair recognizes Mr. Gates for a motion.
Mr. Speaker, I move to postpone further consideration of SB 15 until 9:30 p.m. today.
Members, you've heard the motion. Is there objection to the adoption of the motion? The chair is none. The motion is adopted. Record vote has been requested by Representative Money. Done did. All right. Chair lays it on second reading Senate Bill 12. The clerk will read the bill.
SB 12 by Creighton relating to parental rights in public education, including the imposition of certain requirements and prohibitions regarding instruction and diversity, equity, and inclusion duties.
The chair recognizes the gentleman from Collin County in the brown suit, blue tie, and glasses. He has a watch. He's slowly coming down here. Got his theme music going. Mr. Leach.
I'm trying to slow play so that we've got it working. Hey, Buckley, Brad.
Chair recognizes Mr. Leach again on Senate Bill 12.
Thank you, Mr. Speaker. Members, it's my privilege to lay out Senate Bill 12 to you.
Ms. Gonzalez, for what purpose?
I raise a point of order against further consideration of SB 12 under Rule 4, Section 18B and Rule 4, Section 32B10 on the grounds that the May 13, 2025 witness list included with the committee report of the House Committee of Public Education is inaccurate.
Please bring your point of order down front. Mr. Landgraf on the floor of the House.
The point of order is withdrawn. Chair recognizes Mr. Leach.
Thank you, Mr. Speaker. Members,
Mr. Speaker,
Ms. Gonzalez, for what purpose?
I raise a point of order against further consideration of SB 12 under Rule 4, Section 32C2 in the bill and now substantially materially misleading.
Please bring your point of order down front. Is Mr. Leach on the floor of the House? The point of order is withdrawn. The chair recognizes Mr. Leach to continue on the layout.
Thank you, Mr. Speaker. Members, the United States Supreme Court has continually upheld the principle of a parent's fundamental right to direct the education and the upbringing of their children. Senate Bill 12 in front of you now continues the Texas tradition of supporting and expanding and safeguarding the rights and roles of parents in their kids' upbringing and their children's education. I want to walk through a few provisions of the bill with you as briefly as I possibly can, and then I've got a perfecting amendment that is almost done being drafted. First, the bill strengthens parental rights across children's educational experiences. This bill establishes that guaranteeing a parent's ability to make educational choices, to access school records, and to require consent for any medical, psychiatric, or psychological treatments involving their child. The bill also ensures that parents have full access to their children's curriculum, to library materials, to test scores, attendance records, and ensures that parents are notified if there is any change to their child's mental or physical safety. The legislation further upholds parental authority by giving them the ability to opt their child in or out of specific programs, such as the requirement in this bill that a parent must opt in to a child's sex education curriculum, and this is so that parents can make informed choices that align with their family's values. The bill requires a school board to adopt parental engagement policies and to offer at least 2 in-person parent-teacher conferences per year, and to provide for public comment on these policies and more. Another key provision of Senate Bill 12 is the prohibition of diversity, equity, and inclusion mandates in K-12 public schools. This bill builds on our ban of teaching critical race theory, and it goes further, ensuring that our classrooms remain focused on academic excellence rather than political ideology or indoctrination. The bill prevents schools from implementing DEI requirements in trainings, hiring practices, or granting special benefits based on race, ethnicity, gender identity, or sexual orientation. The bill does, I think importantly, explicitly protect the teaching of historical and cultural significance related to state and federal holidays, ensuring that students continue to learn about our country's diverse history, even history that they might disagree with, without politically driven mandates. The bill has very clear and detailed exceptions allowing school districts to combat real discrimination while also prohibiting divisive DEI concepts. The bill prohibits, in its current form, prohibits the SBOE from adopting curriculum standards requiring instruction on sexual orientation or gender identity, and schools or third parties brought in by the school from providing that instruction. My perfecting amendment that hopefully is almost done being drafted will clarify this in response to some concerns brought by some of you. The bill does include clarifying language to provide organizations such as the Boy Scouts and the Girl Scouts, ensuring that they're not prohibited to meet in a school campus under the bill's prohibitions. The bill also, and finally, addresses the grievance process, ensuring that parents' voices have a right to be heard by establishing a structured and robust grievance process. Do I have my perfecting amendment? Mr. Speaker, members, I do have a perfecting amendment that I'd like to go ahead and offer, and then I'm happy to take questions.
The following amendment, the clerk will read the amendment.
Amendment by Leach.
Chair recognizes Mr. Leach.
Thank you, Mr. Speaker. Members, I trust that this is on your screen. I don't want to get ahead of you. If it's not, just someone yell at me or wave me down and I'll slow down. Members, this perfecting amendment includes suggestions and feedback from many of you, which I'm very grateful for, not only today, but over the past couple days. Specifically, as you'll note, the definition of classroom instruction on page 1 is further defined. Let me give you a little bit of background on this, members. The state of Florida a few years ago passed a bill that was widely debated and hotly contested. And ultimately, a school district under that bill was sued, and the school district and the plaintiffs went to a mediation and ultimately entered into a settlement agreement that clarified some of the provisions of that bill to the satisfaction of both parties, the plaintiffs and the state. What this bill does, what this amendment does, is it tracks the language, not exactly and not word for word, but it certainly tracks the spirit and in many cases the language of that mediated settlement agreement in Florida. I'm happy to take some questions on that if members have those questions. On page 2 of their perfecting amendment, it ensures that relating to DEI policies, if there is a termination of an employee who has violated a school district's DEI prohibitions, that employee must be afforded due process and an opportunity to appeal. I appreciate Representative Cheryl Cole bringing that amendment to me, and that's included in here. It also, Representative Romero brought an amendment just a couple hours ago relating to, when we talk about DEI, this amendment on page 2, lines 19 through 22, will protect a school district's ability to engage in the historically underutilized business program for businesses that are owned by a minority group or by women in accordance with state law. Representative Romero, I appreciate you bringing that amendment. Relating to clubs, this amendment will further clarify that a parent be provided notice with respect to a student's club membership and participation. On page 2, lines 27 through 31, this is I forget who it was that brought me this amendment, someone out there, relating to clarifications on a school district's ability to implement targeted recruitment initiatives. I believe this is Representative Tallarico. And if
Ms. Gervin Hawkins, for what purpose?
Will the gentleman yield for question?
I will. I promise I'm almost done, Representative. If I could just finish this, because I want to give due weight to each.
Not at this time.
Each provision of the amendment. I'm not trying to waste time. I just think this is important to go through. Representative Tallarico brought me this amendment, which protects a school district's school's ability to recruit. Of course, we in the bill prohibit discriminatory hiring practices that would be classified as unlawful DEI. But if a school wants to go, in order to increase the diversity in their hiring pool, if they want to go out and recruit, let's say it's at a historically black college, or if it's at a convention, if they want to go recruit a specific ethnic group to increase their hiring pool, then they're encouraged and allowed to do so under this provision. On the final page on page 3 of 4, this is language on page lines 3 through 7 brought by a few of you, specifically Representative Hinojosa, relating to the commissioner's ability to hold a school district accountable who has been found to retaliate against a student or a parent. The further language, Representative Tallarico also brought a great amendment included on page 3, lines 24 through 26, relating to what classroom instruction, further detailing what classroom instruction is allowed and what's not. As basically what it is anything that's consistent with the essential knowledge and skills developed by the State Board of Education. And on the final page, this is further language relating to requirements for student clubs. Mr. Speaker, thank you for allowing me the opportunity to go through all that. I'm happy to take questions, and I move adoption of the amendment.
Ms. Gervin Hawkins, for what purpose?
Mr. Speaker, will the gentleman yield for questions?
Does
Yes,
gentleman yields for questions?
I do.
One of the first questions I have, Representative Leach, is this is a fairly large amendment. Would it be out of order for me to request at least a 15-minute recess to review this?
I'm happy. There's other members lined up behind you. I'm happy to take their questions if you want to step off for a few minutes to review the amendment, but I'm not going to agree to delay the adoption of this amendment.
So I would like to ask the question on the page 2 of your amendment that speaks to the recruitment of staff.
Which line specifically are you talking
It's
about?
line 27 of page 2.
Right.
So would you agree that research shows that students learn better from people who look like them?
No, I don't agree with that research.
Okay, so you don't agree with that research.
No.
So you're a professional.
Because I'll tell you flat out, my son Landry, who just finished 4th grade, had his best teacher of the. We've had some amazing teachers that look like him. His best teacher ever was this year, and she was Hispanic and looked different than him. And so, no, I do not agree that a student needs a teacher who looks like him or her in order to be an effective teacher.
But you are aware of that research, even though you may not agree with it. You are aware of it.
I strongly disagree with.
I agree. You disagree with it, but you are aware of it.
Yeah, I'm also aware of research that suggests the complete opposite.
That the other question that I have is, with our districts, students are subject to the boundaries that they live in. So
I can hear you. Mr. Speaker, can we get some order?
Members, please take your conversations outside the rail.
So students are limited to the boundaries in which they live, the footprint of the district. Would you agree with that?
That's true in some situations, but not
But
necessarily.
in most situations.
I
Come on,
think we've done a
Representative.
lot
I
of
mean,
work this
these are
session to
simple
allow
things.
students more freedom to go places outside of where they live.
So, but
Students have the ability in some cases to transfer schools and transfer school districts.
in what situations can they transfer school districts when it's boundaries are
That's
set?
outlined in state law.
That's what?
That's outlined in state law, Representative.
But you don't know what reasons they can.
The premise of your question is a student bound? I think you used the word bound by.
No, I said they're boundaries. They're student boundaries.
Sure.
So if
You're
you're in
talking the physical, the geographic boundary of the district? In
Exists.
most cases, that is true. It is difficult to transfer to another district. In some situations, or transfer to another school within a district. But students and their parents do have options to, in many cases, go to different schools or different districts, or to homeschool their kids or to go to private schools.
And are you? Can you cite any instances where public schools are actually going out seeking or doing race-based hiring? Are you aware of any of those situations?
Seeking or doing race-based hiring.
Correct. DEI, as you would say.
Do you have a
it.
specific question about the provision of the bill, Representative?
Well, I'm specifically related here. This is the bill when you say it's limit or prohibit a school district from developing or implementing a targeted recruitment initiative.
Yeah, this was brought to me by your colleague from your side of the aisle, Representative Tallarico, who's right back there. And if you'd like to ask him questions about this, it seemed to be a good idea to me that when it comes to a school district identifying a certain demographic group that they want to use to increase diversity within their hiring pool, that they should be allowed to go out and recruit from specific hiring pools. I found that unobjectionable, and so I accepted his amendment in my perfecting amendment.
So, Representative, I'm very disappointed that we can't have a professional civil dialogue. So, thank you for
I'm
answering
happy
the
to
questions
answer
that you
your
did.
questions, Representative. If you want to continue to ask them, I'm trying my best to answer them, and we'll continue to do so.
Mr. Speaker, will the
Mr.
gentleman
Schoolcraft, for what purpose?
will the gentleman yield for a question?
I will.
Gentleman yields for questions.
Thank you, Mr. Leach. I'm trying to look at your amendment, and I do have a question. I'm looking at page 2, line 26. I think it's a drafting error. You're referencing section 33.0815. I'll wait for you to catch up. Page 2, line 26.
Okay. It's relating to page 6 of the bill, lines 24, starting on line 24.
Right, and you reference section 33.0815.
Correct?
In the
Gentleman's
committee's-
time has expired.
I move adoption of the amendment.
Is there anyone who wishes to speak on, for, or against the amendment?
Yeah. All right, I'm going to have to pull mine down and amend
Chair recognizes Mr. Leach to close on the amendment.
I neglected to mention that on page 2, lines 2 through 5, that part of the perfecting amendment was brought by Tony Rose. I move adoption of the amendment.
Mr. Leach sends up an amendment. The amendment is acceptable to the author. However, a record vote has been requested. All those in favor of the adoption of the amendment vote aye. All those opposed vote nay. The clerk will ring the bell. Show Mr. Leach voting aye. Show Ms. Hinojosa voting aye. Show Ms. Fairley voting aye. Have all members voted? Show Ms. Cole voting aye. Have all members voted? There being 132 ayes and 2 nays, the amendment is adopted. The following amendment, the clerk will read the amendment. Please clear the well of the House. The following amendment, the clerk will read the amendment.
Amendment by Gonzalez of Dallas.
Chair recognizes Ms. Gonzalez of Dallas.
Thank you, Mr. Speaker, members. This bill needs to consider the rights of students as well as rights of parents. This amendment asserts the guaranteed rights that students possess and express within their day-to-day school life. This amendment creates clarity on the rights of both parents and students within their educational experience. There is immense Supreme Court precedent stating the rights students have. For example, the United Supreme Court ruled in Tinker versus Des Moines that students don't lose their First Amendment rights to freedom of speech when on school grounds. Also, within Miller versus California, the guidelines to define obscenity do not rely on language or material that lacks redeeming social value. Ashcroft versus ACLU refines the Miller test that obscenity is no longer defined with respect to contemporary community standards as to not arm anyone with means to attack speech that they are intolerant to. Ordinances and laws cannot single out speech, and this amendment ensures that students' speech are not restricted expression while parents' right to expression within the bill is uplifted. In a case, Erznosnik versus the City of Jacksonville asserts that the government does not have the power to restrict their voice from exposure to ideas that parents may not be supportive of. While yes, schools have the vested interest to respect social, moral, and political values of their community, namely parents, as discussed within this bill, the First Amendment transcends those imperatives as decided in Board versus Education, Island Trees Union Free School District versus PICO. Schools act as a space for voluntary inquiry, and students are the cultural center of the school to seek and discuss information and ideas, especially of diverse content found within group discussions and within the library. So let me be clear, this amendment does not operate outside the current legal precedents held by both the state and United States Supreme Court, nor does this amendment eliminate the express rights of parents. This amendment is about ensuring students have the right to express their guaranteed rights and liberties and to not confuse parental rights within education to expand students' own guaranteed rights. I move adoption.
Mr. Speaker,
Ms. Garcia, for what purpose?
does the representative yield for questions?
Does the gentlelady yield for questions?
I yield.
The gentlelady yields for questions.
Can you please elaborate on what this amendment solidifies?
Sure. So this amendment solidifies and exemplifies the guaranteed rights that students have within a key bill regarding the operation of schools. Students' rights should be expressed with the same emphasis as parents.
And why is this amendment needed?
Well, it's needed because the guaranteed rights of students need to be expressly written alongside the rights of parents as well. Students have the express rights that should be clarified to them in the same vein that parents have express rights clarified to them within this bill.
And then can you please elaborate on how this amendment improves the bill?
Yes. So it improves the bill by including that the rights of students within educational institutions. It is not listed within the bill currently, and it's not expressly written within the bill either. So this should be added. There should be no confusion or exemption about the rights of students.
Does the language within the bill address the First Amendment rights of students in the current form?
Yes. As a flyover thought, within page 6, the bill mentions the prohibition on diversity, equity, and inclusion within schools and the restriction on instruction regarding sexual orientation or gender identity, but states it does not apply to the speech of students. But it does not expressly define their rights beyond citing the First Amendment of the United States Constitution and Section 8, Article 1 of the Texas Constitution.
Is this amendment anti-parental rights?
Absolutely not. Absolutely not.
Thank you, Representative.
Thank you. I move adoption.
The chair recognizes Mr. Leach to speak in opposition to the amendment.
Okay. Okay, thank you, Mr. Speaker. Members, for all the amendments, I know there's a lot of conversations about some amendments being pulled down. For the ones that are not pulled down and that come up, I'm going to leave them to the will of the body. I'm going to oppose certain ones and support others, but I'm not going to move to table any. On this one, I'm going to oppose this and ask that you oppose it with me because I don't believe it's necessary. All of the things that are included in this bill are constitutional rights that are already very clear in our constitutions, both the United States Constitution and our state constitution. I don't think we need statutory language, that at least what's in front of me now, having only had 30 seconds to review it. I'm going to ask that you vote no on the adoption of the Gonzalez amendment.
Chair recognizes Mr. Raymond to speak in favor of the amendment.
Thank you, Mr. Speaker. Members, I'm supporting this bill, and I have supported the author of the bill up to this point, and I know he's leaving this to the will of the House, but I tell people often in this chamber, read the bill. I say read the bill. So I'm going to read this for you because it won't take long. The amendment says, infringement of student rights prohibited. To the extent that fundamental rights are granted to students by their creator and upheld by the United States Constitution, the Texas Constitution, and the laws of this state, including the right to freedom of speech, press, and expression, the right to receive information, and the right to make decisions concerning personal beliefs and ideas, these rights may not be infringed on by any public elementary or secondary school or state governmental entity, including the state or a political subdivision of the state, regardless of the application of contemporary community standards. So I support this because it just makes sense. So members, love Leach over here, love the chairman. He's a great guy, even though he's a Baylor Bear. But read this. I hope if you read it, Van Dever and others, you might vote for it. But I think it's a good amendment. I just think it's a good amendment, and I hope you'll vote for it.
The chair recognizes Ms. Gonzalez of Dallas to close on her amendment.
Again, members, this is not an anti-parental rights amendment. It's just ensuring that it is clearly stated in the bill that students also have rights as well. I move adoption.
Ms. Gonzalez of Dallas sends up an amendment. The amendment is not acceptable to the author. This is a record vote on the adoption of the amendment. The clerk will ring the bell. Show Mr. Leach voting nay. Show Mr. Hefner voting nay. Show Mr. Wilson voting nay. Show Mr. Toth voting nay. Have all members voted? Have all members voted? Show Mr. Hunter voting nay. There being 49 ayes and 83 nays, the amendment fails to adopt. The following amendment, the clerk will read the amendment.
Amendment by Garcia of Bear.
Chair recognizes Mr. Dutton.
Thank you, Mr. Speaker and members. This was an amendment by Josie Garcia, and unfortunately, she's not present right now, and she asked me to lay it out for her. This amendment provides an exception. Right now in the bill, there's some broad prohibitions regarding DEI. And what this amendment does, it permits the recruitment and retention of black educators, male educators, and other underrepresented educators. And let me tell you why that's important, because the way the situation is now, first of all, as most of you know, the teaching profession is dominated generally by about 75% female. And we have a dearth of black male educators, particularly in grades K through 6. There have been some efforts to improve those numbers by doing specialized recruiting of those particular teachers. And what we wanted to do was make sure that we could do that under this bill. And so that's what the amendment does, and I move adoption.
Chair recognizes Mr. Leach.
I am opposed to the adoption of this amendment. It's not necessary, with all due respect to Ms. Garcia and my good friend Representative Chairman Dutton. Members, I'd ask that you vote no on this amendment.
Chair recognizes Mr. Dutton to close on the amendment.
Members, again, the bill has some rather broad prohibitions that don't allow even for agreeing or doing things in concert with federal law, for example. And so what this amendment does is says that we are going to make sure that at least to the extent we have to do something regarding complying with federal law, or particularly specialized programs to recruit certain members, certain staff members, that we just absolutely require that we have an increasing number of. I know some of you don't like this, don't like the whole idea of diversity, equity, and inclusion, but I would remind you of this, and I'm sure most of you know what an antonym is, and if you do, then you'll understand that the antonym of diversity is likeness and similarity. You know, and so I just want you to think about it, because in this case, there is a need sometimes to do certain specialized attention and target certain groups to try to improve our ability to make sure our children get educated. That's what this amendment does, and I would move, ask you to vote no on the motion to table. Well, there's not a motion to table. That's a good thing, and so it'll make it easy for you to just simply vote for the amendment.
Ms. Garcia of Bear sends up an amendment. The amendment is not acceptable to the author. There will be a record vote on the adoption of the amendment. The clerk will read the bill. Show Mr. Leach voting nay. Show Mr. Harris voting nay. Mr. Hefner voting nay. Show Mr. Dutton voting aye. Show Mr. Schatzline voting nay. Show Ms. Zwiener voting aye. Show Mr. Toth voting nay. Show Ms. Bowers voting aye. Show Ms. Ward Johnson voting aye. Have all members voted? Have all members voted? There being 51 ayes and 82 nays, the amendment fails to adopt. Following the amendment, the clerk will read the amendment.
Amendment by Bowers.
Chair recognizes Ms. Bowers.
Thank you, Mr. Speaker. Members, this amendment adds a necessary exception to this bill language and reads, except regarding the teaching of historical and present discrimination more broadly. The bill requires instruction to follow the essential knowledge and skills adopted by the State Board of Education, but we must make room, deliberate and protected room, for the teaching of our nation's and our state's full history, including the uncomfortable truths of slavery, segregation, and systemic discrimination, both past and present. This exception ensures that educators are not silenced when teaching the facts about justice, facts about inequality, facts that are essential if we want our students to grow up informed and equipped to lead in a diverse and democratic society. Teaching about historical and present discrimination should not be controversial. It should be required, and it should be protected. So I urge you to support this amendment and make sure we are not writing selective memory into law.
Chair recognizes Mr. Leach to speak against the amendment.
Thank you, Mr. Speaker. Members, with respect to Representative Bowers, this is already in the bill. If you look at page 5 and 6 of the bill, this is already very clear, starting at the bottom of page 5 going into page 6. Basically, all the way, the entirety of page 6 is what it already covers this. And so I'm going to oppose this amendment and ask that you do the same.
Chair recognizes Ms. Bowers to close on the amendment.
Thank you, Chairman Leach. I just believe that we need to teach the truth. We should not teach a selected or selected history. It should be the absolute truth. And whether it regards racial discrimination of any kind, we have to make sure that our students understand what that truly means. So I ask you to vote for this amendment. I move adoption.
Ms. Bowers sends up an amendment. The amendment is not acceptable to the author. This is a record vote. The clerk will ring the bell. Show Mr. Leach voting nay. Show Ms. Bowers voting aye. Show Mr. Toth voting nay. Show Mr. Alders voting nay. Have all members voted? Have all members voted? There being 50 ayes and 84 nays, the amendment fails to adopt. The following amendment, the clerk will read the amendment.
Amendment by manual.
Chair recognizes Mr. Manuel.
Thank you, Mr. Speaker and members. This amendment is an amendment that will add into the code if your professional duties conflict with your code of ethics. So if you're an LGBTQ person and you're in a group of people and they're telling you that you have to teach about something that is conflicting to what you believe in, or if you're black and it's about white supremacy, or if you are someone who considers themselves a super Christian and you don't want to talk about LGBTQ issues or certain issues, this would just say you don't have to take any of this into consideration. You don't have to do this or be put in those situations. I think it's a great amendment. Hopefully you will support it, and I move passage.
Chair recognizes Mr. Leach to speak in opposition to the amendment.
Thank you, Mr. Speaker. I think this is a great amendment, author. I think it's a really bad amendment, and I'm asking you to stick with me and oppose the amendment.
Chair recognizes Mr. Manuel to close on the amendment.
I still care for the chairman in an agape way, and I move adoption.
Mr. Manuel sends up an amendment. The amendment is not acceptable to the author. This is a record vote on the adoption of the amendment. The clerk will ring the bell. Show Mr. Leach voting nay. Show Mr. Toth voting nay. Have all members voted? Have all members voted? There being 50 ayes and 83 nays, the amendment fails to adopt. Is Ms. Cole on the floor of the House? The following amendment, the clerk will read the amendment.
Amendment by Money.
Chair recognizes Mr. Money.
Thank you. Trying to scramble and find this real quick. On page 6, lines 12 and 13, there's a the bill says nothing in this section may be construed to limit or prohibit a school district from analyzing school-based causes and taking steps to eliminate discriminatory practices as necessary to address achievement gaps and differentials described by, and it's three things: the district plans adopted under section 11.185 or 186, or by section 39.053 of the Education Code. This would take out the district plans in a way that so that the district plans aren't a loophole for them to insert DEI into. They could still have the plans, but those plans are not allowed to be race-based plans. So we think that should be stricken out as it was in the original Senate version. It would still, the rest of that paragraph would remain, and it would still allow the schools to address the achievement gaps under section 39.053.
Mr. Speaker,
Mr. Turner, for what purpose?
would the gentleman yield for a question?
Yes.
Gentleman yields for questions.
Thank you, Representative Money. Thank you for the explanation. I think I understand part of what you're striking, but what specific plans adopted by school districts are you trying to strike from the underlying bill?
Which plans?
Right. So your amendment reads, I don't have the full bill in front of me, so I can't look.
Yeah,
you're on page 6 of the bill, lines 12 and 13.
Right.
And then you're striking the district's plans adopted under section 11.185 or 11.186. So what do 185 and 186 refer back to?
11.185 and 11.186, which is early childhood literacy and mathematics proficiency plans. Schools would still have those plans, but including them in this place in the bill would exempt those plans from the DEI provisions that the bill intends to eliminate. And so this was not in the Senate version, and the reason that the Senate didn't include these provisions, I think, is because it leaves a rather large loophole where ISDs can simply pass a plan that could be overtly racist, for example, if there's a disparity in math or reading scores. So under those plans, they would still be able to address the differentials and achievement gaps, but they could not do it in a way that was race-based.
Well,
if my amendment passes.
Okay. Well, okay, I'm looking at the bill now, and so the bill, starting on page 5, at the bottom of page 5, nothing in this section may be construed to, and then it lists several things, and then gets to the section that you're trying to amend. Limit or prohibit a school district from analyzing school-based causes and taking steps to eliminate unlawful discriminatory practices as necessary to address achievement gaps and differentials described by the district's plans adopted under those two sections. So one section is early childhood literacy, you said?
Early childhood literacy and mathematics proficiency plans. So
that's 185?
That 185, I believe, I don't have it in front of me, is childhood literacy, and 186 is mathematics proficiency.
Okay, got it.
And I think the clear distinction here is Section 39.053 is statute. It's set by the legislature. Section 11.185 and 186, the plans that are adopted there are adopted by the school district itself. And so we don't want to create a situation where the school board of trustees could create a plan that would allow DEI and be exempted from this statute.
I guess I'm trying to understand what DEI would mean in this context. What would that actually be? What would be an example of DEI in
Sure.
analyzing data related to early childhood literacy or mathematical proficiency?
If you had a plan, or were able to create a plan that treated Hispanic kids and Asian kids and white kids and black kids differently as it regards in regards to literacy or mathematics proficiency.
Okay. But my understanding of those types of plans is simply to look at, okay, are there trend lines in student performance, student achievement, and are there, conclusions we can draw with respect to, different data sets and help use that data to help inform strategies to improve childhood literacy, to improve mathematical proficiency in this case. So I don't know where there would be a DEI concern in that. It's simply, if I'm understanding this right, and I think I am, this is simply data that districts will be able to look at as they're developing plans to try to boost their numbers for early childhood learners in reading and math.
And if there's no DEI concern in those plans, then there's no reason for them to be included in a section that exempts them from the DEI provisions of this Senate Bill 12.
Yeah. Well, okay. Again,
I want kids to read.
I know others have questions, but
yeah.
I'm just not seeing the connection between. I understand your concerns about DEI, although I don't share them, but I do understand them. But I don't see how that relates to this specific provision in the code related to early childhood proficiency in literacy and mathematics. So I've got some questions about that, but I'll wait for the bill author to weigh in on it. So thank you for answering my questions.
Sure.
Let me move my stuff out of your way.
Mr. Speaker,
Mr. Schatzline, for what purpose?
would the gentleman yield for some questions?
Does the gentleman yield for questions?
I will.
The gentleman yields for questions.
Mr. Money, almost was in the last questions referring that there isn't DEI, but if there's no DEI, then this amendment wouldn't matter, right? I mean, let's just do it and make sure that there's not. Is that correct?
Yeah, and I think the concern that I have is when it came over from the Senate, it said that nothing in this section may be construed to limit or prohibit a school district from doing these things. Like, in other words, it accepts from the statute DEI as it pertains to a small portion of the education code. And somewhere in the House version of the bill, it added in district plans. I don't know what's all in those district plans, but I don't want to create a situation where those district plans would be able to insert DEI and be accepted from the provisions that we've carefully crafted in this bill to make sure that there's no DEI.
So this just restores it back to the way that the Senate bill would have addressed DEI inside of the original Senate Bill 12, correct?
That's correct. And if there is no DEI in those plans under 11.185 or 11.186, then there's no reason to accept it from the DEI provisions.
So do you think that if we exempt literacy plans that could be a way for far-left administrators to use material that contain DEI, CRT, other items that we're trying to ban?
Yeah, I think it could be. It could create a loophole that would be possible, and I don't think that that's what we're trying to do with this bill.
I think the intent of what you were saying earlier is that it doesn't matter what race you are. The reality is we should have the same standard for all kids, and this is what this amendment goes to do, is to make sure that this, our literacy programs are not inherently racist by treating different kids differently and lowering the standards for those kids. Is that right?
I want every kid in Texas to be literate and proficient in math, and I don't want us to treat kids who are struggling with reading as some of my kids struggled with reading, or some of my kids struggle with math. I don't want them to be treated differently because of their race than other kids that struggle with math.
So do you think, simple question, do you think allowing DEI policies and literacy plans will help kids learn how to read, or do you think it will harm kids learning how to read?
I think that it definitely harms. I think that it's not connected to student achievement, people's race, for example. People should be able to have whatever education they need to help them succeed, and it shouldn't be tailored based on race.
When I was knocking doors, and you as well, talking about policies for education, one of the things I heard over and over and over again was, our low math scores, our low reading scores. Was there ever a moment where someone at the door asked, can you make sure that we have a DEI policy to make sure those math and reading scores got up?
No, absolutely not. And
The gentleman's time has expired.
all right, I move adoption.
The chair recognizes Mr. Leach to speak on the amendment.
Okay, thank you, Mr. Speaker. Members, we're going to leave this to the will of the body. Trust the body to read through this, analyze it in the context of the bill. I'm going to vote yes on this. I'm trusting Mr. Money that what he says this amendment does is what it does, and would just ask you to vote your conscience and your district. I'll be voting yes.
The chair recognizes Mr. Little to speak for the amendment.
Thank you, Mr. Speaker. Members, I just want to make sure that we don't go a little bit too fast here. I'm in favor of this amendment, but I want to explain why. The thrust of Representative Leach's bill is to exclude DEI from our practices and patterns of life in public schools, and that's a noble thing to do, and that is what I'll call the general rule under this statute. And at the bottom of page 5 begin a series of exceptions to the general rule and bases for permitting that information, I'll call it DEI information, into schools. And one of the exceptions that's written on page 6 that's affected by the amendment deals with these district plans adopted under 11185 and 11186, which include childhood math learning as well as military and college readiness. The idea being that we as lawmakers who are not district administrators for school districts, we are simply not creative enough to consider every possible circumstance where DEI might come into public schools, and they are, because they're preparing these plans. So the idea is to not create an exception that consumes the rule that's created by Representative Leach's very important bill. So thank you, Speaker.
Mr. Speaker,
Mr. Dutton, for what purpose?
does the gentleman yield?
Does the gentleman yield for questions?
I do. I hope I can answer your questions.
Gentleman yields for questions.
All right. Let me see if I have an easy question then. What's your take on what does this DEI mean?
I don't know if that's within the scope of the amendment, but I believe DEI is well defined within the scope of the bill.
Well, but you said you thought there ought to be no exceptions in your layout in support of the amendment.
No, I don't think there should be no exceptions. In fact, there's a handful of exceptions already in Representative Leach's bill. I just don't think that we should have an exception that can expand at the whim of the school administrators to consume the purpose of the bill, if that makes sense to you.
Well, are you saying that DEI ought to be limited or it ought to be expansive?
Representative Dutton, I'm sorry. I have trouble hearing you sometimes.
Yeah. What I'm asking is...
Members, please take your conversations outside the rails and keep the well of the House clear.
Mr. Speaker, parliamentary inquiry.
State your inquiry.
Do you know every time you say that, nothing happens?
The chair is not advised.
Okay. What I'm trying to figure out is there ever a situation where something should be race-targeted, race-based? in your opinion?
That's a big question. I'll try to answer it as narrowly as I can within the context of the amendment. So,
Well, in terms of schools, that's what I meant. I should have said
sure, what's built into the bill begins at the bottom of page 5,
Right.
where it says in section D, nothing in this section may be construed to limit or prohibit a school district from acknowledging or teaching the significance of state and federal holidays, like I'm assuming Juneteenth, Martin Luther King Day, or commemorative months. I'm assuming that's Black History Month, and how those holidays or months fit into the themes of history and the stories of the state, etc. So I believe there are reasons to educate students on this topic. I think the purpose of the bill is to exclude race as a basis for hiring or explaining why some people might be entitled to things that other people aren't. So
Do you think that having an increasing number of black male teachers is important?
I don't express an opinion on that, and I don't believe that's within the scope of the bill or
Well,
the
no,
amendment that I'm testifying on.
I'm trying to ask you in terms of the scope of your thinking.
Just what I think in general.
Yes.
I think it would be great to have more black male teachers. I think it would be great to have more teachers of every race, because I think there is a shortage of people who are qualified and willing to serve our state in that capacity.
Well, do you think the shortage is more magnified in terms of black males?
I lack the information to answer your question.
So you don't know?
I don't know.
Okay. But if there was, let's assume there is. I do know that there is. And so I'd be glad to show you all the data
Yes, sir.
that proves the point. But let's assume for the purposes of having this discussion that that is the case. Could school districts would it be acceptable for school districts to target trying to increase the number of black male teachers?
I really don't express an opinion on that, and I'll just say I don't know. I want our students to have the best teachers they can have, and regardless of their race or sex.
Well, yeah, but that ignores the reality of how students learn and what the data that indicates students learn differently, and that certain teachers make a difference in that learning.
I'm not sure whether it does. I'm not a student of that particular topic. I'll just say that there are all types of reasons for both racial and sex disparities in various forms of employment. We don't have a lot of, for example, female aeronautical engineers, for example. It's not because they're not capable. It's just for whatever reason there's a disparity.
Right, but you would buy a target if I said we don't have enough white males in a situation and we designed a program for them. Would you have a problem with that?
I'm sorry, I couldn't hear the beginning of your question, and it's
My
not.
question was, I'm trying to figure out whether or not your thinking is so expansive or inclusive that you would think that if white males were at a disadvantage or disadvantaged by recruiting, you would think that we should do something to help that or address that problem.
To be very honest with you, Representative Dutton, I don't think about that at all.
Well, you know, that's what I'm trying to determine. I'm trying to determine whether or not this amendment would allow a school district to address a problem that it sees or that it determines it has.
I don't think this particular amendment, I think the purpose of this amendment is to close a potential loophole that school administrators could use to consume the overall general rule of the bill.
And what do you say the loophole is?
The loophole being that we are creating, the bill as it stands without this amendment creates an exception for districts to craft plans, for example, military and college readiness plans, to address gaps that it sees. And so the way that they could potentially address gaps as part of their plans is through DEI, and there's an exception for it in the bill currently.
Well, that's what I've been trying to get at. Is suppose the gaps are created that result in those disparities existing within the school district, and they decide they want to address it. You're saying they shouldn't address it at all.
Well, I think the gaps that the people of Texas need to be concerned with are whether all of the students are either college or military ready, or all of the students are meeting math and reading skills as in their particular grade level, not the question of whether there are certain racial or gender disparities that are or may be driving those problems.
Are you married?
Am I married?
Yes.
Yes, sir, happily.
Well, I just the point I'm making is this: if your wife asked you loved her, and you said, "Well, I love everybody," would that answer it?
I don't think it would.
I don't think it would either, and that's what I'm suggesting. You're saying about this program. You're saying that because they need a specialized with a light on it, you want it addressed not with the light, but with something more magnified than that, because you don't believe that ought to be a target.
Well, Representative Dutton, I'm very much enjoying the discussion. I don't know that we're going to be able to solve the particular problem of disparities that may exist. What I hope to do is to make sure that every student comes to school on as even a footing as possible, and that is the lens through which we look at our students inside of a school.
That's unrealistic. That didn't happen.
I'm sorry.
That doesn't happen, sir. That doesn't happen. In an ideal world, I would hope that would happen. But when we, having been on Public Education Committee for almost 38 years, I will tell you that we have had all kinds of people that come to us and tell us, for example, I think one of the child psychologists.
The gentleman's time has expired.
Thank you, anyway.
Thank you, Representative Dutton.
The chair recognizes Mr. Leach. I'm sorry. The chair recognizes Mr. Money to close on the amendment.
I move adoption.
The question, Mr. Money sends up an amendment. The amendment is acceptable to the author. However, a record vote has been requested. The clerk will ring the bell. Show Mr. Leach voting aye. Show Mr. Verdell voting aye. Show Mr. Toth voting aye. Have all members voted? Show Mr. Alcott voting aye. Show Mr. Tinderholt voting aye. Show Ms. Isaac voting aye. Have all members voted? There being 83 ayes and 48 nays, the amendment is adopted. The following amendment, the clerk will read the amendment.
Amendment by Toth.
Chair recognizes Mr. Toth.
Speaker,
Ms. Weiner, for what purpose?
I raise a point of order under Rule 11, Section 2 against further consideration of the Toth Amendment.
Ms. Weiner, please bring your point of order down front. The point of order is withdrawn and the amendment is withdrawn.
Okay.
The following amendment, the clerk will read the amendment.
Amendment by Dutton.
The chair recognizes Mr. Dutton. Chair recognizes Mr. Dutton.
I'm sorry. This is not a DEI amendment. This amendment simply says, well, let me tell you the reason for this amendment. The reason for this amendment is there are certain kids in our schools, certain students, whose parents may not be actively involved in their schooling. The kid may go home with a survey or something from the school, and the school never hears from the parent. And so what this amendment tries to do is say, well, first of all, it's an unfortunate reality that these parents are not involved in their schools, in their child's life, insofar as the school is concerned. And what this amendment simply says is that to the extent that a district gives a survey to the student or requests the student to take something home and come back with it from their parent, if they don't come back with it within 15 days, the district will send a second one home with the student. And then if that doesn't get the parent's attention, the school district can go ahead and do it. The other thing that this amendment does, it just simply requires the school district to post any surveys on their website. And there are no questions. I move adoption.
The chair recognizes Mr. Leach to speak on the amendment.
Thank you, Mr. Speaker. Members, again, great bill author, really bad amendment. This, with respect to Chairman Dutton, this would allow, in certain circumstances, even if the parent doesn't respond, this would allow a school district to survey a student, to get information from a student, to require a student to respond to a questionnaire without parental consent, and that's not something I'm comfortable with, and I'd ask that you vote no.
Chair recognizes Mr. Dutton to close on the amendment.
Thank you, Mr. Speaker. The only thing I would say to that is, for some of you who may know this, Mr. Leach may not be young enough to know it, but we don't all have Leave It to Beaver families. And so not having that means that somehow or another there has to be a default provision that accomplishes what we're trying to do. And the default here is that the school district can go ahead and do it, but only after giving the parent an opportunity to do it twice to comply with the survey. I just don't think that gets too far out of line with this bill. I think that actually helps this bill because it puts more into the hands of, more power into the hands of the parents, so that the parent can actually choose to get involved in the child's education life, but if they don't for some reason, and that does happen, that's the reality. If they don't happen to get involved, I don't think that ought to stop there, but we ought to go the next step, which is allow the school district to go ahead and make the decision. And I move passage.
Mr. Dutton sends up an amendment. The amendment is not acceptable to the author. This is a record vote. The clerk will ring the bell. Show Mr. Leach voting nay. Show Mr. Dutton voting aye. Show Mr. Alders voting nay. Show Mr. Harris voting nay. Have all members voted? Have all members voted? There being 49 ayes and 75 nays, the amendment fails to adopt.
Thank you, Harold.
Is Mr. Schatzline on the floor of the House? The following amendment, the clerk will read the amendment.
Amendment by Schatzline.
Chair recognizes Mr. Schatzline.
Thank you, Mr. Speaker. And members, this amendment strikes a section that would allow schools to counsel on sexuality without parental notification. We need to make sure that we empower parents and do not undermine them. I move adoption.
Chair recognizes Mr. Leach to speak on the amendment.
I like this amendment. I'm going to vote for it, but will of the body. Well, I'm not moving anything because it's not my motion.
Chair recognizes Mr. Schatzline to close on the amendment.
Move adoption.
Mr. Speaker,
Mr. Tallarico, for what purpose?
would the gentleman yield for a couple of questions?
As the gentleman yields for questions.
Thank you, Representative Schatzline. I'm just trying to figure out exactly what your amendment does. So you are striking in the bill the exception for a child to be able to consent to counseling. Is that what am I understanding that correctly?
So what this amendment would do is essentially it's ensuring that children can't be socially transitioned without a parent even knowing that this is happening. And so what this amendment touches on is emotional abuse. So what we did was we made sure that abuse can still be reported. We made sure that if neglect is happening, physical abuse, sexual abuse, that these counselors can still have access to be able to help those children. However, emotional abuse is subjective. It's something that we can't really define. It's one of those things that this could open up an entire slew of topics that we could talk to kids about that should have parental consent if we're going to talk about them.
Yeah, you mentioned that it was opening it up for children to get counseling about sexuality. I'm not seeing that in the part of code that you're removing. If I'm looking at the consent to counseling section of code, it's a child may consent to counseling for suicide prevention, chemical addiction or dependency, or sexual, physical, and emotional abuse. Is that what you're...
Yeah, and what we struck in there was the part that talks about emotional abuse. That's what we're hitting on, because here's our idea. And really what we're touching on is emotional abuse, because it cannot truly be defined. What we're looking at is a situation where if emotional abuse is said to be being done, whether we agree with it, whether I agree with it, or you agree with it, it opens up the counselor's ability to talk about anything without consent. And so that's the idea, is that if emotional abuse is in there, is that it removes the parental consent requirement in order for that counselor to talk with the student about subjects.
But it's not opening the counselor up to talk about anything. It's just these three things that are in statute: that suicide prevention, chemical addiction, or sexual, physical, or emotional abuse. Is that
right?
I just want to make sure I'm
so
understanding.
I'll give you a scenario. So if a student comes in and says, "Dad says I throw like a girl," right? And all of a sudden they say, "Well, that's emotional abuse." And when that happens, all of a sudden it's looked at as I get to open up the door and say, "Well, I can talk to you without parental consent right now about different topics because you have just disclosed something to me that allows me to skip the parental permission within this.
And so you are leaving in the reporting requirement. Is that right?
Yeah, so that's why we put affect the duty to report child abuse or neglect under Chapter 261 Family Code, or an investigation of a report of abuse or neglect under this chapter, or under that chapter, excuse me, because we want to make sure that if there is legitimate abuse going on, that this counselor has the ability to intervene, has the ability to step in and say, hey, let's get you some help, let's report this, so that we can make sure that that student is safe.
I guess what I'm trying to figure out is if 2 is about affecting a child's consent to counseling about these things, Section 3 is about reporting if there is abuse. How will the counselor know there's abuse possibly happening if the child is not able to consent to that counseling to begin with under Section 2?
Well, remember, what we're looking at is when we talk about the different types of abuse, we're not changing the family code. So that's still protected. Like, counselors can still talk about well-being. And if a child opens up and says, I'm being physically abused at home, I'm being sexually abused in this situation or scenario, this immediately allows that counselor to intervene. What we don't want is when emotional abuse is talked about, when all of a sudden it's like, well, all walls go down, and now that counselor gets to talk about anything they want with this student. And so that's the goal of this amendment, is to make sure that counselors can do their job and still intervene in emergency situations, but they're not undermining parents with ideologies that those parents didn't consent to.
So if I'm understanding this correctly, if we adopt your amendment, a counselor would need to get parental consent to talk to a child about possible abuse at home?
No, because we're not amending the family code. Those counselors already have that ability. What we're saying is this is not going to open up a door where it says a simple, my father or my mother said this to me. And we label that as emotional abuse. So now these counselors can waive any ability to have to reach out to that parent and say, hey, what's going on here? There's supposedly emotional abuse here, or you said this. They wouldn't have to do that. They can just dig in and begin to say whatever they would like to that child.
Well, let's just set aside the emotional abuse for a second, because this 2 is inclusive of all kinds of abuse. Is that right?
Yeah, and that's why we put right here in this line to affect the duty to report child abuse or neglect.
No, I know.
Under Chapter 261 Family Code, or an investigation of a report of abuse or neglect under the chapter.
So I guess what I'm trying to figure out is how a counselor will be able to figure out if they need to.
It's super simple. So I worked in public schools as well. I know you did too. It starts as a conversation, as you know, when a student walks in, whether it's a classroom or whether it's with a counselor, and we say, hey, how's your day going? What's going on at home? The moment that a student alludes to sexual abuse, physical abuse, you see bruising, you see anything that presents itself, that's a moment where you need to report. But when we look at this emotional abuse, that's so broad. I mean, when we talk about emotional abuse, it's difficult to even define. It's difficult to walk through on, because at the end of the day, it's going to be defined by that counselor. And I'm sorry, but I don't really trust that a counselor is going to be able to make the decision to be able to say, you know what, that constitutes me going above the head of the parent. That constitutes me undermining the ability to get permission from a parent to be able to have a conversation with this student. And look, at the end of the day, if we're really about parental rights, we want to make sure that if a situation arises where a counselor or a teacher or someone in the school disagrees with one little thing or ideology that we may be taking at home. Let's say that counselor has a different religion. Let's say that counselor doesn't like that in our house we follow the 10 Commandments. That's the moment where all of a sudden a counselor gets to say, are you being emotionally abused by 10 Commandments to be talked about inside your living room? That's the moment where, we don't want to give that power to that counselor without parental consent.
If your concern is about the emotional abuse part of this, why is that not just carved out? I'm worried that we're taking out the physical, sexual abuse, chemical addiction, dependency, suicide
here's the
prevention.
best part. We're not, because we're not changing the family code, which is why we reference it. So when we say verbally asking the child about the child's general well-being, or affect the duty to report child abuse or neglect under Chapter 261 Family Code, or an investigation of a report of abuse or neglect under that chapter. That's actually why we added that in, because at the end of the day, you're right, we want to be able to ensure the protection and the safety of that child if they are being physically abused, if they are being sexually abused, but we don't really want the discretion of a counselor to say, oh, you're being taught about this concept that I might disagree with. That sounds like emotional abuse to me, because that opens the door for ideologies to be pushed on our kids without parental consent, and I just don't think that's right.
Well, I'm worried that we're just leaving out a big area in the middle, right? You're leaving in simple, quick checks for how a kid's doing, when they walk into the school.
Well, that's great. That's great. I'm glad you said that, because that's why we also said verbally asking the child about the child's general well-being.
No,
it
I'm
opens
saying,
the door.
No, I'm saying that's in there. That's great. And then you've also got reports when we know there's abuse happening. I'm trying to figure out, there's a big gulf between those two things.
That gulf you're talking about is the concept of a counselor having the discretion to undermine parents, and that's why we removed it. That big gap is us saying, hey, we're going to be super
The
pointed.
gentleman's time has expired.
And we're going to make sure that parents aren't undermined. Thank you. I move
Mr.
past.
Schatzline sends up an amendment. The amendment is acceptable to the author. However, a record vote is required. The clerk will ring the bell. Show Mr. Leach voting aye. Show Mr. Schatzline voting aye. Show Mr. Toth voting aye. Show Mr. Anchia voting no. Show Mr. Tinderholt voting aye. Show Ms. Gervin Hawkins voting no. Have all members voted? Show Mr. Dutton voting no. Have all members voted? There being 85 ayes and 50 nays, the amendment is adopted.
Oh, were you talking back there? The following amendment, the clerk will read the amendment.
Amendment by Schoolcraft.
The chair recognizes Mr. Schoolcraft to explain his amendment.
Thank you, Mr. Speaker and members. This amendment adds a paragraph back into the bill that originally was there when it came over from the Senate. The paragraph says, certain student clubs prohibited, a school district or open enrollment charter school may not authorize or sponsor a student club based on sexual orientation or gender identity. Again, that was in the Senate bill when it came over.
Mr. Speaker,
Ms. Sweener, for what purpose?
I raise a point of order against further consideration of the Schoolcraft amendment under Rule 11, Section 3, that the amendment is on opposite of the bill.
Please bring your point of order down front. The point of order is withdrawn. The chair recognizes Mr. Schoolcraft on his amendment.
Mr. Speaker.
He probably used 1 minute. Mr. Anchia, for what purpose?
Thank you, Mr. Speaker. Will the gentleman yield for some questions on
Gentleman,
this
you for
amendment?
questions.
I will in a minute.
Not at this time.
Okay, thank you.
Members, sexual orientation and gender identity, they're difficult issues, they're confusing issues. We've got kids going through this, trying to navigate it during their difficult and confusing teenage years. These issues are also extremely controversial and divisive and potentially disruptive in our schools. At their core, sexual orientation and gender identity are about human sexuality. As a matter of state policy, this legislature has determined that human sexuality is a topic that our schools should address through close coordination with parents and through age-appropriate lessons taught by trained professionals in our sex education classes. This amendment simply ensures that our public schools continue to respect the central role of parents and the clearly expressed policy of this state on matters dealing with human sexuality. I will yield for questions.
Mr. Anchia, for what purpose?
Will the gentleman yield for a few questions, please?
Gentleman yields for questions.
Thank you. Thank you, Representative Schoolcraft. I see that in your amendment, the term sexual orientation is not defined. Well, how do you define it?
Actually, I believe in statute it is defined. I don't have it in front of me.
What is your idea of sexual orientation?
I don't know that I can define it because it's a very fluid term. It could mean a lot of things.
Give me some examples.
Well, let's see. Sexual orientation would be...
What is your sexual orientation, by way of example?
Let's just stick with what's in the bill as far as we don't want to talk about me.
Well, I just thought illustratively, you might be able to generalize from your specific experience. What is your orientation?
Well, you tell me. You tell me what you think.
Members will confine their remarks to the amendment.
I'm unable to know your orientation, and that's why it would be difficult for me to answer the question you posed. So let's try to navigate what you just said is a very fluid thing. What is the basket of things that sexual orientation might consist of?
Well, it seems to be changing fairly routinely. Is a cultural matter. Socially, letters keep getting added. It could range anywhere from heterosexuality to well, just a lot of different orientations.
All right, so I'm not sure that it's any clearer from that definition. How about gender identity? How do you define gender identity as opposed to sexual orientation?
Well, I define gender identity as male or female.
Okay.
However, there seems to be some confusion over that.
So a person can identify as a male or a female?
Let me continue with this. The whole gender thing is gotten very, very complex, it seems, because I was looking at a website getting ready for this discussion, a group called the Gender Sexuality Alliance. They're ones pushing some of these clubs in our schools, and I noticed that when you applied to be part of their organization, someone's expected to specify what their pronouns are, which of course are related to their gender identity. And the list they provided, so I guess they're experts at this, started with...
Would you qualify them as experts in this area?
With he, him, his, okay. The next ones were she, her, hers, okay. Then it was they, them, theirs, and then E/IM/IS. Or
and what does that refer to?
I have no idea.
Okay.
Those are pronouns that people can select to identify under.
So you would agree
it's
then...
me/nim/nymphs. or XE/XEM/XYRS.
So you
Or
believe
then-
that
and then
you
it
believe
ends
that is
with,
the
"I don't
that is the
know."
universe of. So again, that seems to be pretty broad, does it not? And would you agree with that?
Sure, it can be very broad. That's one
Okay.
reason that it's very difficult for somebody who's not trained in following curriculum and so forth to really provide this kind of guidance or to get involved in this.
Okay, so it sounds like in both of your answers, gender identity is broad and sexual orientation is broad. What about parental rights? Yeah, this bill is about parental rights, is it not?
Well, that's among other things, yes.
Okay, so it's about parental rights. And what if I, as a parent, wanted to give my child permission to attend a club at school that has an affinity for certain orientation or identity, gender identity? Would that be allowed under your amendment?
Well, state policy, what we have done in our education code is provided that human sexuality is to be dealt with in schools under sex education classes using curriculum and parameters set about by the State Board of Education.
But
and
let's be
TEKS.
clear, currently there are clubs based on orientation, sexual orientation, or gender identity. So if I wanted to give my daughter permission to form that club or attend that club, your amendment trumps my right as a parent. Is that right?
That's correct.
Okay, so you would not be permitting a parent to provide permission, right? The government instead would be telling a parent whether they could provide permission. Is that correct?
That would be correct. Also,
Okay.
I would also be reflecting, and my decisions would affect all the other parents and all the other students on that campus, not just this one parent. That's
So
why
your
we have.
view-
That's why we have a policy that applies around the state when it affects a lot of people.
So as a
everyone.
politician in Austin, you would supplant your judgment via this amendment for the judgment of a parent who wanted their child to participate in these clubs.
No, I would apply my position and my decision here based on what I think is best for the entire population, including the parents and the other students in that school.
So what you think is best is more important than what a parent thinks is best, just to be clear.
When it comes to state policies, that's
Okay.
what we do all the time. Every policy we pass here is our determination of what it is best for our citizens and our constituents.
So just to be clear, you think your judgment on whether a parent should be able to allow their child to sponsor a student club based on sexual orientation or gender identity would preclude a parent from doing that. Your judgment, it will supersede the parent's right to do so.
No, this actually wouldn't supersede the parent's right to do anything. This determines whether or not that club exists.
Right, but if a parent gave their child permission to sponsor this club, to participate in this club, you're going to say no, right?
If we determine that these clubs should not exist on campus, then what I say has nothing to do with the parent's decision. They don't have a decision to make. There's no club.
Mr. Speaker,
Ms. Gonzalez, for what
will the
purpose?
gentleman yield?
Gentleman, yield for questions.
I will yield for questions.
Gentleman yields.
Do you realize that your amendment now brings in the Girl Scouts and the Boy Scouts and, some of the Christian male athlete organizations?
Actually, no, it does not.
Actually, it does. And
Actually, it does
And
not.
I will ask the bill author, and he will confirm. We have now gotten confirmation that you
No.
are now impacting Girl Scouts and Boy Scouts because gender identity doesn't just mean when we're talking about trans identity. It means all. So if we are talking about higher ed, it's to be fraternities and sororities. Gender identity does talk about boys and girls, and it is confirmed that you are messing with the Boy Scouts and Girl Scouts. Thank
Actually,
you.
no, that's not correct because you tend to be confusing gender with gender identity. Gender is
Gentleman's
an actual
time has
fact.
expired.
I move adoption.
The following amendment to the amendment, the clerk will read the amendment.
also said we'll fix it later if that's true.
Amendment by Turner.
I wouldn't let him
Chair
do that.
recognizes Mr. Turner on the amendment to the amendment.
Thank you, Mr. Speaker, members. So, Mr. Schoolcraft's amendment is dictating to school districts certain types of student clubs, student organizations that they cannot allow. Personally, I don't think it's the business of the legislature to tell our school districts what types of student clubs should be allowed or disallowed. I think those decisions are best left in the hands of our schools and our school districts, and fundamentally at the local level. But if we're going to go down this road and open up this door to say certain types of student organizations should not be permitted, then let's have a discussion about what other types of student organizations maybe are not appropriate. So I have a handful of amendments to address this concern. The first one you have before you say we're not going to allow student clubs, organizations that are centered around anti-vaccination theory. We have a tremendous problem in this state and in this country where people who are opposed to the science of vaccines that are proven to be safe and effective and have saved millions of lives in our country, those vaccines are under attack and being doubted and being questioned and being falsely labeled as unsafe or ineffective. And right now in Texas, as I think everyone here knows, we are in the midst of a historic measles outbreak in the state that has already cost lives in Texas. And measles, I would remind the members, was as recently as the year 2000, just a generation ago, was declared to have been completely eradicated in the United States of America. But now, here in the state of Texas, in the year 2025, we have a full-blown measles outbreak underway. The last count I saw was well over 700 confirmed cases in the state of Texas. So we do not need to do anything in our K through 12 schools that would allow this anti-science, anti-vaccine mentality to take hold with our young people. And so my amendment would simply say that any student organization that is centered around anti-vaccine theory, anti-vaccine science, the junk science that it is simply not going to be allowed in our public schools in this state. And I hope it's acceptable to the author of the amendment.
Mr. Wu, for what purpose?
Would the gentleman yield for questions?
Gentleman yield for questions.
Yes.
Gentleman yields.
Mr. Turner, did you know that right now there is, in fact, a new COVID variant making its way through across the globe at this very moment?
I have heard that, yes.
Yeah. And potentially this may cause another massive wave because another massive wave of deaths and illnesses because this is a different enough of a variant that it could cause problems that the current immunizations are not going to be sufficient.
Yeah, that's right. And I think that's one of the things that we've seen with the COVID vaccine specifically is that the vaccine manufacturers have updated the vaccine continuously, just like we do with the flu vaccine every year, to be able to adapt to mutations in the virus and adapt to the new strains to provide the best protection possible. But there's no protection when people don't get vaccinated. And it's a real health. We know millions of lives were lost globally to COVID-19.
And more specifically here in the United States, 1.2 million Americans have died from the COVID virus itself in the last few years. Were you aware of that?
Yes, I am. That's exactly right. And we only began to get out of the pandemic and bring those death counts down once the vaccine became widely available.
And
thanks to Operation Warp Speed. We'll give President Trump credit
absolutely.
for Operation
And
Warp Speed.
You realize that? Did you know that also the vast majority of deaths following the release of the vaccine were those of people who were unvaccinated?
Yes. Yeah, absolutely. There's a huge disparity in terms of vaccinated versus unvaccinated persons with respect to the impact of COVID, both in terms of deaths and serious illness.
And in fact, experts largely blame the anti-vaxxer movement for people having hesitancy about receiving that vaccine and refusing to take that vaccine, often leading to their severe illness or death.
Well, that's exactly right, and tragically we see that in diseases beyond COVID. Measles most contemporaneously because of this massive outbreak we're seeing. We know that there have been a lot of just fake news, for lack of a better term, about several vaccines, including the MMR vaccine, which is measles, mumps, rubella, that it could cause other conditions, and that's been completely debunked. It was based on a fraudulent report from a British doctor back in the late 1990s. But these rumors take hold over the internet, and some parents, no doubt wanting to do the right thing for their kid, but they had bad information. They had this false information, didn't get their kids vaccinated, and now they're sick.
And just like Mr. Schoolcraft talked about how his amendment was not about protecting kids and making sure that those kind of things are not discussed on school grounds, it is important for public health and the safety of that school to not have those kind of discussions. If we can't have those kind of discussions, we shouldn't have these kind of discussions either, because if those are dangerous, then these are dangerous.
Well, absolutely. Our schools should be a place of learning true information and learning facts and science. Our schools should never be a place of disinformation, of spreading lies.
Absolutely.
And spreading lies that can lead to serious illness or even death. Yep. So this is, I think, a common sense amendment to make sure that doesn't happen.
Absolutely, and it's especially important because many of our schools, because we can see the vaccination rates for many of them, are dropping below the herd immunity threshold because of the anti-vaccination movement.
That's exactly right. I'm glad you brought that up. Herd immunity is generally, for most vaccines, 95% vaccinated population. We have schools, I know, in Tarrant County for measles, for the MMR vaccine, that are in the 80 percentile. That is exceedingly dangerous. So those low percentages are ripe for an outbreak. And if an outbreak occurs, that means very serious illness for someone who's not vaccinated against those diseases.
Thank you. This is a sensible amendment.
Thank you. I move adoption.
Does anyone wish to speak on for or against the amendment to the amendment? Chair is none. Recognizes Mr. Turner to close. Mr. Turner moves to adopt the amendment. He sends up an amendment to the amendment. Oh, do you want to speak against? Chair recognizes Mr. Schoolcraft to speak against.
I'll be brief. Members, all right. I ask you to vote no on the amendment.
Mr. Speaker.
Vote no on the amendment to the amendment.
Mr. Speaker, would the gentleman yield?
Does the gentleman yield for questions? Gentleman, not at this time, Mr. Turner. The chair recognizes Mr. Turner to close.
Members, I walked to the back mic a moment ago to ask Mr. Schoolcraft why he was opposing this amendment, because he said that in the layout for his own amendment that he was interested in protecting Texas school kids. And that's what my amendment is about. It's about protecting Texas school kids from misinformation about life-saving vaccines. And there's way too much misinformation in our country and in the state in particular right now with respect to life-saving vaccines. I wanted to ask Mr. Schoolcraft what his issue was with protecting kids from what he perceives as a threat versus what I know to be a threat, and I think all of you know to be a threat, which is that not enough people are getting vaccinated in our state. Unfortunately, he chose not to take my question, so I don't know what his opposition is. But members, I think you all know the value of vaccines, despite the political rhetoric around this topic sometimes. I think most of you, if not all of you, have gotten your own kids vaccinated, your grandkids vaccinated, and that's the right thing to do because it protects them, it helps them grow up healthy, and it keeps them safe. And we should want that for all Texas school kids, and we should not want any organization on a public school campus in the state of Texas spreading misinformation and lies that could potentially lead them to make unhealthy decisions in their lives. So I hope you'll vote for this common sense amendment to the amendment.
Mr. Turner sends up an amendment to the
Move
amendment.
adoption.
It is not acceptable to the author. Record vote has been requested. The clerk will ring the bell. Show Mr. Turner voting aye, Mr. Schoolcraft voting nay, Ms. Hinojosa voting aye, Mr. Hunter voting aye, Mr. Schatzline voting nay, Mr. Buckley voting nay, Ms. Fairley voting nay, Mr. Hunter voting nay. Have all members voted? Show Ms. Gervin Hawkins in the back voting aye. Have all members voted? There being 50 ayes and 85 nays, the amendment to the amendment is not adopted. Ms. Weiner, Ms. Weiner, for what purpose?
Mr. Speaker, I raise a point of order against further consideration of the Schoolcraft Amendment under Rule 11.8b, that it affects a matter previously inserted or stricken out of the original bill.
Please bring your point of order down front.
The point of order has been withdrawn. The amendment is withdrawn. Following amendment, clerk will read the amendment.
Amendment by Toth.
Mr. Toth.
This amendment prohibits the district from adopting procedure prevention and transitioning. Move adoption.
Mr. Toth sends up amendment. It is accepted the author. Record vote has been requested. Clerk ring the bell. Mr. Leach voting aye. Toth voting aye. Busey nay. Mary Gonzalez nay. Chris Turner nay. Bojani nay. Nate Schatzline yes. Have all members voted? Have all members voted? Shelley Luther aye. Gervin Hawkins no. Have all members voted? Have all members voted? 82 ayes, 48 nays. Amendment's adopted. Anyone wish to speak on, for, or against the bill? Mr. Leach to close.
Move passage.
Oh, Ms. Hawkins, for what purpose? Ms. Gervin Hawkins, for what purpose?
I rise a point of order against further consideration of Senate Bill 12 under Rule 8, Section 3, on the grounds that the bill contains two different subjects.
Bring your point of order. Bring your point of order down. Ms. Gervin Hawkins raises a point of order against further consideration of the committee substitute for Senate Bill 12 under Rule 8, Section 3 on the grounds the bill contains more than one subject. The committee substitute for SB 12 is a parental rights education bill that, among other things, contains provisions making it easier for parents to be engaged in their child's education. Ms. Gervin Hawkins argues that Section 2 of the bill is on a different subject than the rest of the bill. Section 2 requires certain information to be reported and publicized about school facilities. The public report contains information that is useful to parents who want to know more about and become more engaged in their child's education. The section is on the same subject. Accordingly, the point of order is respectfully overruled. Question occurs on SB 12. Record vote. Clerk, ring the bell. Ms. Rose voting nay. Have all members voted? Have all members voted? 85 ayes, 48 nays. Senate Bill 12 passes at third reading. The speaker's desk is clear. Two quick motions. The following message from the governor, the clerk will read the message.
To the members of the House of Representatives and Senate of the 89th Texas Legislature regular session. Pursuant to Article 5, Section 14 of the Texas Constitution, I, Greg Abbott, Governor of Texas, do hereby disapprove and veto House Bill 353 of the 89th Texas Legislature regular session due to the following objections. Keeping Texas children safe is one of the most sacred responsibilities of our government. The adult lurking around the playground fence seeking to lure a child away should be kept at bay. But this law does not target him. Instead, this law would make a criminal for anyone who merely is present near a school or daycare center, even absent an unlawful or threatening act. In fact, the bill sweeps more broadly than that. The criminal prohibition applies to any grounds or buildings on which an activity sponsored by the school or daycare center is being conducted, and any public property located within 250 feet. The problem? Schools sponsor activities on Capitol grounds and in other places daily. But by the bill's plain terms, the tourist inspecting the heroes of the Alamo Monument, an Austin resident listening to an orchestra performance in the rotunda, and the lieutenant governor and speaker of their house arriving for work, all of them must obtain written consent or court criminal liability. That is surely not what legislators intended, but it is what they wrote down. I look forward to working with the author to draft a more tailored approach to protecting the Texas children, without criminalizing ordinary conduct in public spaces. Until then, Texas law already contains a criminal trespass offense that allows school officials and law enforcement to remove individuals who do not belong on school grounds or who pose a risk to student safety. Since you remain gathered in regular session and continue to conduct formal business, I am delivering this disapproval message directly to you along the unsigned, official, and unenrolled copy of the bill. Respectfully submitted, Greg Abbott.
Ms. Lopez of Cameron for a motion.
Mr. Speaker, I move to recommit SB 2188 to the Committee on State Affairs.
Members, you heard the motion. Is there an objection? Chair is none so ordered. Ms. Isaac for motion.
Mr. Speaker, I move to recommit Senate Bill 16 to the Committee on Elections.
Members, you heard the motion. Is there an objection? Chair is none so ordered. Chair announces the signing of the following in the presence of the House.
HB 12, HB 33, HB 34, HB 39, HB 45, HB 47, HB 130, HB 148, HB 285, HB 305, HB 742, HB 908, HB 1024, HB 1318, HB 1443, HB 1533, HB 1866, HB 1902, HB 2001, HB 2355, HB 2402, HB 2434, HB 2440, HB 2490, HB 2560, HB 2697. HB 2733, HB 2775, HB 2802, HB 2894, HB 3161, HB 3228, HB 3421, HB 3424, HB 3510, HB 3986, HB 4042, HB 4476, HB 3238, HB 4344, HB 4413, HB 4426, HB 4429, HB 4783, HB 4850, HB 4945, HB 4996, HB 5515.
Ms. Lopez of Camera moves the House adjourn until 2 p.m. Sunday in memory of Arturo Edward Sanchez of San Benito. Is there any objection? Chair hears none. The House stands adjourned.